Okay. Bismillahirrahmanirrahim. Nahmaduhu wa nusalli ala rasulihil kareem. Amma ba'd. So today we are going to talk about the second pillar. Yeah. So we already talked about the definition of contract. Then we talked about what are the contract could become unlawful, batil. Right. Then we talked about what is arkan, which mean the pillars. Then why do we call it pillars? Then we talked about the different opinions of the scholars with regard to the pillars, right? We talked about majority scholars, they go for three, and the Hanafi scholars, they go for two, which is basically the first pillar of the majority scholars, okay, which is ijab and qabul, yeah, acceptance, sorry, offer and acceptance. Then we talked about the forms of expression, whether it is verbal or actual action based or verbal based, oral based. Then we talked about even the conditions of after acceptance. We talked about clarity, conformity, continuity, right? Okay. So now we are going into the second. We are going into the second. What they call it? Um, the pillar. Yeah. Okay. So the second pillar is actually what? Who? So the first pillar is actually we talked about how. How do we do the expression? How do we make expression? The second one, who is the party? Who is the person that actually dealing? Number three is what? Actually, what? That is what? What exactly we are selling? So that is, so we talked about it, right? How, who, and what. Remember all these three principles of, sorry, three pillars. So today we are going to talk about the second pillar. All right, I think second pillar, probably we cannot finish the whole thing today. So we're gonna need one more class for this to finish. So today what we're gonna see is actually uh, how do you define the parties? Yeah, how do you define? Who are they? Who is eligible to do contract? Who is not? Uh, in what age a person is becoming eligible to do contract? Look again, the reason why we are learning all these in details, you know, why we are learning, it is actually because Sharia is always promotes maslahah. So that's quite important. If there is no maslahah concept, this all actually become irrelevant. Because you know, when you see if someone is selling, or should I see, why should I care about who is selling? Because all I care about is the product. I don't care about who is selling. Let's say if a minor is selling, what I mean by minor is actually someone like 10 years old or 5 years old. Uh, so why should I care about, you know, the age of the person who is selling? I should only care about the product, right? So these are the questions comes. I tell you, um, because when you are buying something from a minor or from a lunatic. What I mean by lunatic is actually someone is crazy, is not actually understanding what he is doing. Someone is actually, you know, lost his mind, and then he has something, and then he say, okay, take this, give me money. He could say that, you know, okay, take my iPhone, give me 10 ringgit, right? Because number one, he is a minor, or maybe he is a crazy person because he is not completely fit. He is not completely fit to do the business. So now you might be saying, what is that actually? What is that actually supposed to do with me? What am I supposed to do for that? Because that's not my mistake, right? You will say that why should I care? You may think that why should I care? You may think that why should I think about the other party, because all I should think about only the property or the things that I'm getting it for cheap. So these are the justifications that sometimes our mind always always gives. Our mind is sometimes it will manipulate you. Sometimes it will deviate you. That's what the minds do all the time. Don't think that mind is good. Sometimes even it is a kind of evil mind. Sometimes good mind, sometimes evil mind. So we need to know the differences. So what I'm trying to tell that, the first basic question comes that why should I care about him, whether what he is and who is, what he is selling or not? Because Sharia wants to promote justice. All right, as a Muslim, there is no doubt that I am whether I am following Sharia or not, because I cannot say that I'm a Muslim but I don't follow Sharia. It is impossible. Then you have to say kalima and then you have to become Muslim again. If you say that I'm Muslim but I don't follow Sharia, because as a Muslim it's compulsory. It is fundamental. Fundamentally, every Muslim has to follow Sharia. That is because Sharia is a Quran and Sunnah, and everything that related to Quran and Sunnah. So if I have to do some transaction, I have to make sure that I'm not I'm not um, conveying or uh, preparing a kind of injustice. I'm not actually posing any injustice to anybody, because I will be asked. You see, every single penny that I spent, I earned, and every single penny that I spent, I have to answer to Allah subhanahu wa ta'ala. You know that hadith. Without answering for every penny, my feet will not actually move from the place, one place to another place. This is what's gonna happen in the day of judgment. Everybody has to stand for quite long actually, right? So that's really a terrible day for everybody, because everybody has to answer for everything that we do. Sometimes intentionally, sometimes unintentionally, sometimes we don't even remember. But don't worry, you don't have to remember. You don't have to remember, because there are a couple of other responsible people that we are. They are not people, responsible angels. Yeah, they are actually remembering every single act of yours. So that's the reason why when you do any transaction, we need to think about it, whether the person is the right person to do, whether he is a qualified person to do or not. Most of the cases is a qualified. Mostly it is qualified. In few minor cases, we need to revise this. That's the reason why we are learning. If that is the case for one individual person, what about uh, a community? What about a country? Because we see today how a developed country is actually ruling on uh, developing countries, or maybe the third world countries, right? So imposing the taxes, and then extracting all the resources, and then paying the salary. It is you can every single issue that we are discussing in this class, you can look into two ways. Number one is actually micro level. At micro level is actually you and me personally, what we are doing, how we have to deal with it. And then also you can think about macro level, right? Because everything also related in in a country, in a community, a government to government. There are strong governments, there are weak governments, there are strong countries, there are weak countries. Similar to strong person, weak person, rich person, rich, poor person. Same thing goes to rich country, poor country. So we don't want any injustice to happen. That's what actually the maqasid of Sharia, the objective of Sharia. Anyway, coming back to the class, I want you to understand this. I want you to give it to you, as easy as possible, because sometimes the slides um, may make you confused. All right, so don't be confused. So please note it down what I'm going to say. All right, when you look at the parties, all right, the one buyer and seller. We talk about buyer and seller both. We call them parties. There are, basically speaking, two types of them. All right, one is passive receptive capacity. All right, so we call it capacity, meaning to say in Arabic ahliya. Ahliya means capacity. All right, so now you should have the capacity, then only you can start doing transaction. When you do transaction, there are some transaction you have to do, you have to initiate. Hmm? There are some transaction, it will come to you, you don't have to initiate. For example, if someone gives you a gift also a kind of transaction. All right, my property is actually, my stuff is actually going to your hand, and then my ownership, because when I give you a phone, let's say for example, I give you a phone and I say it's a gift, it's a hadiya, hiba. Then what does it mean? It means my ownership gone, and then your ownership comes. After I give it to you, you become the owner. I have no right to go and take it back. It's because I have given to you. This is what actually hadiya, a gift. So you become the owner. So there is a transaction, right? Let's say after my father passed away, right? So his inheritance, I become the owner of his properties, right? It is also coming to me. I'm not actually initiating. I'm not actually, ask my father, you should write your property on me. After he passed away, automatically it comes to me. You got what I'm saying? So now to put it into perspectives, there are some transaction will come to you. All right, so we call it rights. All right, we call it rights. There are some transaction you have to initiate. It is so it becomes obligation. Okay, when you are supposed to initiate, for example, you have money, you have properties, and you have to pay zakat. So now you have to pay to somebody. You have to initiate zakat to pay somebody. So it is called obligation. All right. Let's say you are hiring something rental, and at the end of the month you have to pay rental. So obligation. When you are buying from someone, you like the phone, you bought it from the shop. Now the obligation is what? You have to pay money. So remember, the right is actually something to receive. All right. Huh? And then the obligation is something to do. Okay. Now, when you look into the parties, anyone can do this. Not necessary that only the adult has to receive the gift. Even small kid, even the lunatic, even the crazy person also can get the gift. Am I right? Anyone can get inheritance. Not necessary that because he's a crazy, he cannot get the inheritance. They will not say that, okay, he's a minor, so don't give him the inheritance. Not like that. If a father passed away, if there are three children and two of them are adult and one of them is a child, they will not separate. They will not actually separate because of he is adult and he is a child. They should give the they should give the inheritance regardless of their age, right? So now you need to understand that this is called capacity. Okay, the capacity can go into ahliya al-wujub. Ahliya al-wujub means it's a passive or receptive capacity. So I will come back to you. The second one is actually ahliya al-ada, which is actually active or legal capacity. So now you may have, I think you can understand slightly from what I said earlier. The first one is more into receiving. This is what we call passive receptive. See, receptive capacity. Huh? More into receiving, for example, receiving the gift, receiving the inheritance, these kind of things. So we are talking about, the smallest, uh, and also the one who lost his sense, that kind of, that kind of, incomplete, or maybe we call it, the capacity, but they don't have the capacity adult. All right. The second one is actually what? It's actually active legal capacity. This active legal capacity, those actually who are able to do the transaction, okay, who are able to do the obligation. So now let us see one by one. I don't want to get confused. That's why I give you this all right. Let me tell you, give you the definition of ahliya: the eligibility of a person to establish right for an obligation upon himself. See, he is eligible to establish, he is eligible to give you something. So you are receiving you are receiving the right. At the same time, he is also obliged to do something. This is what we call capacity technically. Yeah. Okay. All right. I will come back to the next sentence. I don't want to read especially this one right now. Let me come back to that, because sometimes it will make you confusion. All right. Okay. This is what I've been telling you. All right. It is clear. You have two types of capacities. Number one is receptive capacity. The other one is active capacity. In Arabic, they call ahliya al-wujub, ahliya al-ada. All right. Now we need to know the examples for these two capacities. All right. So before I go into the slides, I want you to make this, and I want you to understand this. So please write it down. All right. Each and every ahliya has two types. For example, receptive capacity, ahliya al-wujub, has two types. One is incomplete, the other one is complete, which means incomplete receptive. Then you have complete receptive. The other side, you have active capacity, ahliya al-ada. Again, it's the same thing. There is a incomplete active capacity. There is a complete captive active capacity. All right. So now how many you have altogether? Four. You got me? How many you have?
Four.
Very good. So you have a two here, two there. Now, let me start giving you an example of incomplete receptive capacity. It's actually fetus, starting from fetus. You know fetus, right? The baby inside the womb. The baby didn't come out. All right. Start from there. Okay. Fetus is the example for incomplete receptive. Then you have complete receptive, which is actually a child. All right. A child, for example, 2 years, 3 years, 5 years, this is the child, is actually complete receptive capacity. All right. Then you have active capacity, as I told you, incomplete and complete. So for incomplete, you have the example of, everyone who actually, okay, a child who is actually becoming mature. Okay, for example, a child when he is 8 or 9 or 10 years old, even though before he become the adult, the stage before he become the adult, let's say 15 or 16, before that, within that 10 to 15 years, maybe 8 to 15 years. So these are the time period. We call it asabi al-mumayyiz. Sabi al-Mumayyiz, which means distinguished child. Because this child is different from the child who is 4 years old or 5 years old. Because this child, Sabi al-Mumayyiz, can understand which is right and wrong. So we call it distinguished child. All right. This is the example for incomplete. Then you have example for complete. I think you all know. Can you tell me what is the example of complete active capacity?
Adult.
Exactly, everybody. Everybody else, adult. All those adult who is not a minor, who is not actually lunatic or crazy or losing their mind. Everybody become what? Complete active capacity. Yes, is it correct? Okay. Then we didn't talk about those lunatics and those who are adult but who lost their mind. Those kind of people will also come under incomplete active capacity. All right. So I am giving you this example so that the next slides will not make you confused. All right, so that's very important. So start from the fetus, and then the child, and then the Shabi al-Mumayyiz, and then you have the adult, complete adult. All right, okay, let us go one by one now. Okay, so Ahliya al-Wujub, it refers to the capacity of a person to receive a rights and obligation. All right, he will receive rights also and obligation. It is possessed by all living human being, of course. You have complete and incomplete. Incomplete receptive capacity is a type of capacity that enables a person to receive only rights. Remember, incomplete is actually what? He will receive only rights but not obligation. What does it mean? A fetus, a fetus, there are few things that fetus can get, but the condition is a fetus should come out as a baby. As long as it is fetus, yeah, it will get, but if it died inside the womb, if the fetus uh, died inside the mother's womb, then it won't get anything whatever it's supposed to get. For example, yeah, there is a fetus, and then there's a baby in tummy, the baby in the womb, and then suddenly the father passed away, right? So what happened that the baby, the fetus also get the inheritance. You got what I'm saying? So there are a couple of things like this, which inshallah I will tell you. Fetus is a part of the mother as it does not have an independent personality, but still there are few things that the baby can get it. All right. So let us see what are the things that fetus can get it. Okay, these are the things. There are four things. The fetus is entitled to certain essential beneficial rights. There are four of them. Four rights. Remember, the fetus nothing to do with zakat. The fetus has nothing to do something to give you something because it has no obligation. It will only receive rights. Huh? Number one, a fetus has the right to be attributed to his parent, right? And then it will share the inheritance, and then it will share a will. Maybe a grandfather may say that, okay, whatever inside the womb, whether boy or girl, I'm actually writing this property on this baby in the fetus, as a fetus. It is possible. Someone can do the wasiyah, can write will. Someone can also share in waqaf. All right, but all these things is actually subjected to the baby. I mean, the fetus should be born alive. If it didn't, if it didn't born alive, it was not born alive, then there is no question of all this, right? All everything will be will go away. All right, so this is the example for incomplete receptive capacity. Then you have complete receptive capacity. Okay, it refers to a capacity through which a person receive rights and obligation. All right, so this one you read later. This one sometimes confusing, this part. Okay, okay, talk about this one. Okay, here, what is it actually? The example is the children. Every children comes under complete receptive capacity. Those children with guardians, remember, there are guardians. So now they receive rights and obligation as the guardians are acting on their behalf. All right. They can enter into the contracts of sale or gift. They can do sale, but they cannot do by themselves. Their guardians will do on their behalf. All right. Let's say there's a property. The child cannot sell the property to someone. Child cannot sell anything to anyone unless the guardian, the guardian could be, of course, the guardian is a father, mother, or, the grandfather, these are the people, or uncle, these are the guardians will do on their behalf. But they also have to pay zakat. This is what actually a kind of obligation now. A child has to pay a zakat or zakat al-fitr on his property. Let's say father passed away, the child has a property, and the child has a kidai, child has a shop or factory is running, then every year the zakat must be paid from the factory, from the shop, from the house, but he cannot pay, but he will ask the guardian to pay on behalf. All right. But there are a couple of different views. Hanafis, according to Hanafis, a child is not obliged to pay zakat, and they say it's because, like, he has nothing to do with praying, he's nothing to do with fasting, then why should he pay zakat? All right, but majority scholars, they say he should pay zakat. That's because zakat is not from him, it's from the property. The property is still functioning. So as long as the property is functioning, and as long as you are generating or maximizing the profit from the property, from the business, then you have to pay zakat. But according to Hanafi, is a different view, because they say including criminal liabilities is not there. If a child did something wrong, there is no criminal liabilities, so as he cannot punish. And then they also say because of that, he doesn't need to pay zakat. But majority, they say he has to pay zakat. Okay. Next, moving on into Ahliya al-Ada. Okay, the first one is clear, right? Okay, Ahliya al-Wujub is clear. We talked about fetus. We talked about the children, child. Now we're going to talk about the second type of Ahliya. It refers to the ability of a person to manage his wealth and exercise his rights and undertake obligation in a manner recognized by Sharia. So this is the reference definition for Ahliya al-Wujub. Sorry, Ahliya al-Ada. Okay, the principal elements for the capacity of performance ahliya al-ada are, of course, the first one is the puberty, and also the intellectual standard. He has to become a man and woman. He has to become also intellectually standard. All right, he is a man or he is a woman. He is mature. He actually become adult. At the same time, his intellectual standard is not up to that level, then he will not become under this. All right. Okay. So this is what we call it active legal capacity. Again, we have two things. Number one is we have incomplete, we have complete. Let us talk about incomplete. So what is incomplete? A child between the age of 8 and the age of puberty. Let's say from 8 to 15. According to the majority scholars, is a 15. All right. He has a incomplete capacity to attain rights and responsibility. See this one? He has an incomplete capacity. So we call him Sabi al-Mumayyiz, a child who could distinguish between good and bad. So now the question comes, what are the differences between the child who is actually less than 5 years old and then the child who is less than 15 years old? Of course, you can see clearly there are lots and lots of differences, right? Because this child, Mubayyiz, this child who can distinguish between good and bad, he knows the transaction, he understands it. All right. So now the question comes whether, because the other child, the one less than 5 years old, there is no doubt anything he can do, but he has to do with the permission of sorry he has to he cannot do, but the guardian will do. All right. The child under 5, he cannot do anything, but the guardian will do for him. But here, the guardian still there, because if you are less than 15, remember, you are supposed to live under the guardian. All right, you have to live under the guardian. You cannot do something without the permission of the guardian. So now the question is, can he do anything, any transaction by himself, or he has to get permission from the guardian? All right, can he do something with the permission of the guardian? Can he do some business with the permission of his guardian? Or can he do anything, any business without the permission of the guardian? So now we have a couple of different views. According to Shafi'i and Hanbali, a distinguishing child does not have the requisite capacity, because he has no capacity, which means that he cannot enter into any contract with or without permission of his guardian. So meaning to say that they treat him like a child. They treat him like a child. They say that only the guardian can do the business, the transaction for him. All right, he cannot do anything by himself. But according to Hanafi and Maliki, there are differences. I think most probably this is a very good point. They say that there are three types of contract that he can actually do. They are classifying the contracts into three. They say that three types of contract he can do. Number one, beneficial contract. It is valid without the guardian's permission. To receive gift. To receive gift, you don't need permission from your guardian. You can actually receive your gift. But if the baby is actually under 5, usually, when someone gives something to the baby like 3 years old, 4 years old, the baby always look into mama. Mama, can I take it? It's like okay, the mama said, okay, you can take it. Papa, can I take it? You know, it kind of thing only happens if the baby is less than 5. But if the baby is more than 5, he can understand the right and wrong. Then he doesn't need any permission from the guardian to receive gift or will or inheritance. All right. Number two, this is according to Hanafi and Maliki. All right. Aqad that causes loss. If anything that actually causing a loss to him, even with his guardian's permission, is wide. Sometimes, to receive gift is okay. To receive gift is okay. It is permissible. It is good. But what about to give to give a gift to somebody? What about to give sadaqah to somebody, to give money to somebody? All right, this is something that will cause him the loss. So he himself cannot do it. Even they said, if there is some business which is actually will any transaction, not necessarily it has to be business, because in business we don't know whether it goes to loss or, I'm talking about, let's say spending something for somebody. Let's say suddenly he wants to offer food for everybody. All right. So he cannot do even with or without the permission of the guardian, because that's something causing loss. He can only do that once he become adult. He cannot loss. He cannot cause something loss to him. Number three, that the third classification that we're going to talk about, any transaction that may cause either benefit or loss. It's like a sale or a hire or partnership. It's a kind of business. Now we are doing business. If there's any business, remember, you can do. If you are a Sabi al-Mumayyiz, you can actually do, but you need to have a approval of the guardian, because guardian is actually more mature than you. So the guardian will tell you, okay, this business you can do. Okay, this hiring you can do. Okay, this partnership you can do, because he will see what is good for the child, what is good for the that Sabi al-Mumayyiz. All right. So three things: beneficial akad, and then a beneficial transaction, and then we have number two, the transaction that causes loss. Then number three, we have the transaction that may cause either benefit or loss, which is actually, we call it what, PLS, profit loss sharing, profit loss sharing. So these are the things are there, the three classification of contract for Sabi al Mumayyis. Okay, next we have complete active capacity. I think you clearly know who is complete capacity to acquire rights and responsibility. He can enter into any transaction without the need to get anyone's approval. He is a baligh, a major. People like you and me, we can actually do anything on our behalf. We can do any, you can do any transaction. We don't need any approval from anybody. Right, I know. Still, you will ask your father and mother, Mama, can I sell this? I need some money. It is good for you to ask your mother. That's because ask your father. That's because the things that you are going to sell is not yours. It is your father's, it is your mother's. That's the reason why you have to ask them first and then to sell. That is different from here. Here, if you are the owner and you are the owner, it is yours, then of course Sharia is telling you, you can sell to anybody, you can buy from anybody, you don't need any transaction, you don't need any approval from anybody. Yeah. Let's say a husband doesn't need approval from the wife to do that. A wife, in most of the cases, a wife also doesn't need any approval from the husband to sell her property. But if the joint property is a joint, then of course both of them sit together. They need to talk before they sell. So this is what actually Sharia implements. The principal element for the complete active capacity are the puberty and the intellectual standard that a person has attained. This enables him to distinguish between useful and harmful, profitable and unprofitable things or transactions. Okay. They also says that, some, according to some majority scholars, according to Hanafi, it is actually the major age is actually 18 for males and 17 for females. Other scholars, they say it is 15 for both male and female. Every person who has reached the age of major may enter into contracts of sale and purchase, rent, wakala, partnership. So the age is actually, we leave it to you. I mean, we leave it to your country, your Sharia scholars, because there are differences country to country. Some countries, their age, their maturity level, and then some countries, their age, they only know, because maybe many years back they mentioned this age, but this age must be followed according to the law of your country. So let's say your country, in which age that they are telling you that you are adult, maybe 18, in some places maybe 21, maybe some places in 17 or 16. It is all up to your country